Hi, everybody. Hey, I've missed you. Welcome. Welcome to True Crime Wednesday. I'm Lori Hellis, retired criminal attorney and author, and we have a lot to talk about tonight. I want to just say hello to the first few people in the chat, especially to Julie Reichart, my lunchtime pal while I was in Boise. I miss you, Julie. You need to come out to Central Oregon and visit. And hi to Jen Dixon. A little trouble seeing at that distance, and to Pamela. So welcome everybody. Glad to have you here. We've been off for a couple weeks, so we do have a lot to talk about, even though things get a little slow over the holidays. Usually we don't have trials going on over Christmas. It's sort of typically a slow period. But we did have some developments. You know, I keep saying that I'm going to work a little bit harder on my lighting because I look sort of like the crypt keeper. So I apologize for that. And I am going to work a little harder on getting my lighting better. And at some point in the very near future, I am going to paint these battleship gray walls so that the light will bounce a little bit more complimentary. So sorry about that. Keep saying I'm going to work on my lights. So forgive me that I look kind of washed out and like the crypt keeper. I don't seem to be able to warm it up much. So I wanted to talk first of all about the why. I always get the letters wrong because we had YSL. YNW Melly case. This is Jamel Demons, and it's a Florida case, very similar to the YSL case. They've been using RICO to attempt to get yet another group of people who are musicians, rappers, and have a music label. And so they've gone after Jamel Demons. It's a little bit more specific because this is a case where Demons is accused of having murdered his longtime friends and bandmates, and then trying to make it look like a drive-by shooting. The jury hung on his first trial, and he is scheduled to be retried for this case. He has been in custody for in excess of 2,000 days. And he was subjected to a very long trial, and the jury was hung. And you might remember that the prosecutors were also thrown off the case because of misconduct. So now the prosecutors, I think, in an act of retribution, have one of Jamel Demons. He goes by YNW Melly. So they have one of his lawyers, Raven Liberty is her name, under investigation. The defense team found out that Liberty was under investigation because the prosecution went to Apple with a search warrant. And that Apple notified Raven Liberty that she was the subject of a search warrant. But the prosecution did not tell the defense that that was the case. Now, she has not been charged, but she is under investigation. And of course, that raises all sorts of red flags for conflict of interest. So what we know about what she's under investigation for is the state is investigating her for possible witness tampering. Now, Jamel Demons Melly is also been accused of witness tampering, And the prosecution, just in a hearing in the last couple of days, confirmed that the investigation of Raven Liberty was in association with Mr. Demons. So it raises a potential conflict. So the judge set aside 2 days to do an omnibus hearing. Omnibus means we hear all the motions that are pending. So this judge, who has a very full capital case docket, set aside 2 days to hear all these motions. And there's something like 18 or 20 pretrial motions that need to be heard before Melly's trial. And the defense came to court and said, Judge, we can't take up any of these motions because we don't know whether we're going to actually continue to be Mr. Melly or Mr. Demons' lawyers or not, because we don't have enough information to know whether we're in what would be considered a mandatory withdrawal situation, or where we're in a situation where we need to explain to Mr. Demons the breadth of the investigation and give him the sort of lay out the options and what the possible consequences could be, whether he waives the conflict and keeps Raven Liberty on, or whether they are actually in a position where it's not optional, that they have to withdraw. They said, we don't have enough information. We don't know about what this potential investigation encompasses, so we can't advise our client. So the judge went back to the prosecution and said, you issued this subpoena a year ago. It was a year ago in December of 2023. You knew this information. Why didn't you disclose it to the prosecution or to the defense? The prosecution said, well, it's an ongoing investigation. It was so ridiculous. And that the judge pointed out, you could have waited and not brought this. You could have decided not to pursue this investigation and issue this warrant for her phone because you knew that it was going to throw a monkey wrench into the murder trial. And so you brought this on yourself, basically. So the judge said, the defense said, well, at a minimum, we need to see that warrant and the probable cause affidavit so that we know what the scope of this investigation is and we can explain it to Mr. Demons. Because, see, one of the conflicts is what happens if they're both indicted, the lawyer and Demons, for witness tampering. Now that lawyer has a conflict because their client has become their co-defendant. That's horrible, because now Raven Liberty's own self-interest, her interest in her own liberty and her own case, are diametrically opposed to those of her client. And that is a very clear conflict. So I think the state did this as revenge because the defense very clearly pointed out that the prosecution had engaged in illegal activity. So for those of you who didn't necessarily follow the Melly case, what happened was the lead prosecutor on that case questioned a detective. And it's been a little while, so it's going to take me a minute to remember. So what happened was Melly's mother was called in to question, and she had her cell phone. And so they were waiting for a warrant for her cell phone. And she and a detective were sitting in a room with Melly's mother. And Melly's mother was kind of messing with her phone. And they were worried that she was erasing things or she was deleting stuff. And they took the phone away from her. They didn't have the warrant yet for her phone. And the warrant didn't come in until later. But they took her phone to keep her from making changes or whatever. And as they walked out of the room, a deputy walked up with the warrant and said, I have the warrant. Well, the detective had the phone in his hand, and essentially in the comment in front of the prosecutor was, as far as anybody knows, we had the warrant when we took the phone. So they illegally took the telephone. And the prosecutor was involved in an illegal search. And so when that came out, that prosecutor was disqualified. They had to bring in a new prosecutor at the last minute, which probably had a lot to do with the fact that they hung the jury. And there was legal action and ethical action taken against that prosecutor. So now we come to today. As sort of as revenge, the prosecution started going after Melly's lawyers. And so they've gone after this defense attorney whose name is Raven Liberty. And they've said that she was somehow involved and in cahoots with Melly in trying to tamper with witnesses. So the judge pointed out that they could have waited to begin this investigation into Liberty. They didn't have to go forward with it, but they chose to. And so the judge said, you have to release the search warrant. Now, the state came up with a case that says that they didn't have to release the probable cause affidavit, but they did. But the judge did order them to release the warrant. So then the prosecution stands up and says, well, okay, judge, but can you just give us a month before we have to release the warrant? We want a month to think about this. And the judge said, Mr. Demmons is going to trial in September. I think it's the first part of October, for come hell or high water. And we're not taking that date off. This guy's been in custody 2,000 days. We're not taking that date off. So you better figure it out. And so then the prosecution said, well, we're worried that the warrant also covers other people and that might tip somebody off or for the investigation. And so the judge agreed that he would review the search warrant in camera. He also said, I cannot imagine that I am going to redact anything out of the warrant, but I will review it in camera, which, if you remember, just means that the judge is going to review it in his chambers off the record and then determine what gets released. So he said to them, you need to have that warrant to me by February 14th, and I will make a decision on whether to release it or not. Melly's next hearing is set for February 18th. And at that point, they're going to try and decide as many of the outstanding motions as they can. So I'm just double checking my notes from the hearing to make sure that I covered everything. So the judge did decide to, the defense objected to the judge reviewing the warrant the judge said over their objection that he was going to review the warrant and release it, but he was not happy about the prosecution's machinations and that they were dragging their feet. And there is a partial stay in the case because the prosecution took some matters up on appeal from the last after the last trial. So he talked to Melly about his rights to have conflict-free counsel and reminded him that it was his decision alone to decide that, and cautioned him that he needed to think very carefully about that. I mean, part of the problem is that the court is saying, I mean, it's kind of a similar problem to Sarah Boone. Now, he's got a defense team that has been on his team that tried the last case that hung the jury. He's got this team. But the question is whether or not they can continue to represent him because of conflict. So it may be as simple as Raven Liberty getting off the case, but it could also be it also could be that the entire team has to get off. So we will know more on the 18th of February about how they're going to go forward and what Jamal Demons is going to do about the conflict. In the meantime, the judge is going to review the warrant and the warrant that went to Apple and decide what or what not to release to the defense. It's interesting that really the warrant has to do with a separate case, a case that has not been filed yet when it comes to Raven Liberty. I believe charges against Melly have already been, witness tampering charges have already been filed against him, if my memory serves. So we will wait to see whether or not the judge is going to let the prosecution continue with these kind of questionable games. You know, just sort of as an aside before we move on, one of the things that is interesting me right now is that there are several cases, this one, Karen Reed, Richard Allen, that make me question where our criminal justice system is and makes me wonder what it is about our political climate that has caused us to have so many of these cases where there seems to be very clear government misconduct, whether it is prosecutors or law enforcement. It just seems to be a theme. And at first I thought, well, maybe it's always been there, and maybe we just didn't see it because the cases weren't so public. And maybe the fact that that LawTube is covering these cases and they're much higher visibility, maybe that has something to do with it. But as I have thought about these cases, I don't think that's true. I think that there have been some real shifts in our political climate and some real shifts, and I don't talk politics on here, but but my question is, how have the last, say, 10 years of our political climate and our Supreme Court climate impacted criminal justice really at the grassroots level, at the boots on the ground level? How has it had that? What sort of impact has it had? And is there a connection between that and these cases that we're seeing that appear to be government overreach, that Defense attorneys are the last line of defense against government overreach, um, prosecutorial misconduct, law enforcement misconduct, um, judicial misconduct. Defense attorneys are the bulwark against that. And the impression I get from the defense attorneys that I talk to who are still out there in the trenches, because I'm retired, I'm not, is that their job is getting harder and harder in that way, harder in the sense of spending so much more time protecting clients' due process rights against prosecutors and law enforcement overreaching and um, engaging in misconduct. I'm concerned about that, and it is something that I'm thinking may be my next project. So stay tuned because it is something that I find troubling um, in all of this. Um, so that said, there was the continuation of a Daubert hearing on the Karen Reed case. Karen Reed is the case out of Massachusetts where Karen Reed is accused of having in a on a very dark and snowy night when everyone had been partying, and she is accused of having backed into or hit her Boston police officer boyfriend, and and then left him to die in the snow. The defense believes that she dropped him off at a house that belonged to a couple of other police officers from the Canton PD. Canton is a suburb of Boston, and they were all friends. And they believe that he was got into some sort of an altercation in the house, was beaten up, and then thrown out into the snow. So one of the things that the defense has believes is that in the house where John O'Keefe was going to the party, the owners of the home had a German Shepherd dog. The dog had been a police dog in training that had washed out of training. So this happens every once in a while. You have a dog who starts down the training route, the very rigorous police dog training. And for one reason or another, they don't have the temperament or they don't have the ability, and they wash out of the program. And those dogs are usually available for adoption. Well, who hears about a dog that might be available for adoption but cops? So it's not at all unusual for a police officer to have a dog that washed out of its police training and has some police training. So this dog's name was Chloe. She was a big German Shepherd. So one of the things that was concerning was when John O'Keefe was taken to the hospital where he later passed away, one of his arms had a whole series of scratches of, let's say, vertical abrasions, vertical injuries, and what appeared to be puncture marks. So the defense has always opined that John O'Keefe went in the house, that he got into some sort of an altercation. Chloe, who had been trained to some extent to be a police dog, jumped into the fray and bit and scratched John O'Keefe. She was a powerful dog. So Interestingly enough, during Karen Reed's first trial, this Dr. Russell reached out to the defense team and said, I saw a picture of these injuries and they really look like classic dog attack injuries. And because it was kind of the middle of the trial, they vetted her and she is incredibly qualified, and they brought her into the trial. And when they brought her into the trial, they had to stop in the middle of the trial and hold what they call a Daubert hearing. So anytime that you bring in an expert, you have to qualify that expert. You have to prove to the court why that expert can come and testify, why they know what they know, how they're an expert. So one of the things that happened was they did the Daubert hearing, and they found out that Dr. Russell started out in police work. She was a police officer for a while she, in between sort of her undergraduate and her medical school. At one point, she left medical school for a while to take care of a sick parent that then passed away, and then went on to medical school. She is trained not only as an ER physician, but as a forensic doctor as well, as a pathologist. And so she did autopsies, she did um, uh, pathological studies, and she worked in the ER. At one point, she worked in an ER where they treated a lot of police officers whose dogs were going through training. And she said, I have probably treated 500, at least 500 dog bites as an ER physician. And so they, the judge found that she was qualified to give an expert testimony about the patterns of the dog bites. Well, now the prosecution, in preparation for the new trial, for Karen Reed's new trial, is trying to exclude all that evidence. So they filed to exclude Dr. Russell. So they had a 2-day, Daubert hearing, which is long. And they had her on the stand, and she was the absolute perfect expert witness. She was very clear about her training. She was very clear about what gave her the authority to assess those wounds. She was very clear. She stood up to their cross-examination beautifully, and never was ruffled. Never let the new prosecutor get under her skin. She was just the commensurate professional. And so Judge Cannoni took it under advisement. In his argument, the defense attorney pointed out that she had already qualified this person as an expert, and now they've had more time to vet her. She's had more time, actually prepared a written report, which the prosecution has. And so Judge Cannoni took it under advisement. I'm sure that she's going to make a decision shortly, but I expect that she's going to find that Dr. Russell is an appropriate expert on the issue of the dog bite injuries. Interestingly enough, the day that hearing happened, which was, I think, yesterday, at the end of the day, the prosecution also filed motions in limine to keep out the FBI experts who testified last time. So what happened in this case was, because there was some pretty clear law enforcement shenanigans going on, the FBI got involved in investigating the law enforcement shenanigans. And one of the things they got involved in was in double checking what law enforcement had done to investigate the crime. And they brought in their incredibly qualified experts who just blew gigantic holes in the prosecution's case. So now the prosecution wants to keep them out. It's crazy. I don't see how Judge Canoni orders that they stay out. They weren't hired by the defense or the prosecution. They were hired by the FBI, and they are some of the most incredibly qualified people to talk about biomechanics, about the mechanics of injury on a body, and the accident reconstruction. So we also know that the prosecution has asked for further testing on Karen Read's vehicle and all of the GPS and all of the start and stop and movement data from her car. What we see that it has been happening, and we've seen it, we have seen it in other cases as well, is that the companies that make the software that actually analyzes that data are constantly coming out with improvements and updates and new versions of their software. And each time there's a new version of the software, law enforcement is going back and running the data through the newer updated software. So I think that's happening in Karen Read as well. Now, the defense has hired their own experts, and the case will continue. I think it is staggering to learn that Karen Read is about $5 million in debt for this trial. And they have destroyed her. They have destroyed her professionally. They have destroyed her character. I mean, it really is tragic. And it is, having viewed the first trial, the prosecution simply did not prove their case. And I think that, you know, a retrial is always a second bite at the apple, but it's a second bite at the apple for the defense too. And I think this defense team are very capable and very prepared to meet anything the prosecution is going to try and throw at them. So now her case is set for the 1st of April Fools. And it's interesting, I have not gotten too far into any of the peripheral cases, but there are also cases out there, because there was such a groundswell of people say on the side of Karen Read is innocent, and there's this whole Free Karen Read group, and they were literally squaring off on the sidewalk with the Karen Read is guilty people. And there were clashes, and there were confrontations outside bars, and there were confrontations between those groups that led to criminal charges and restraining orders, and it's been crazy. And I don't really have an opinion about who's right and who's wrong amongst those people, but this is a case that created such passion that now we have people going out and confronting one another and confronting witnesses in the case, and being being confronted by witnesses in the case, and it resulting in criminal charges. So I think it's all fine and good when people feel passionate about a case and support a side, support a defendant who they might believe is innocent. However, we can't let it get to the point where we're in physical confrontations with people and we're yelling and screaming at one another across street corners, from street corner to street corner. I mean, we shouldn't be reducing the process to that, even outside the courthouse. We shouldn't be treating our justice system like a WWE match. We should be treating our justice system with reverence. So I've not gotten involved in that. There's a guy out there who goes by Turtle Boy, Aiden Kearney, Kearney, I think is how he pronounces it, Aiden Kearney or Carney. And I think there are a lot of people who think that he's in the right. He's a podcaster and claims to be an investigative reporter, and he is very firmly in the camp that Karen Reed is being unfairly treated, and that she's innocent, and that that she should be acquitted. And he is absolutely convinced that the Canton Police Department, and with the help of the Massachusetts State Police, Michael Proctor, railroaded her to protect the people that were in the house. And that may be true. I don't know. But I do know that in the last trial, the prosecution didn't prove their case. They hung the jury. Come to find out, the jury actually had acquitted Karen Reed on 2 of the counts and was hung on the 3rd. And unfortunately, the judge didn't do the sort of inquiry that would have revealed that. And the jury was dismissed, and she declared a mistrial. Unfortunate, because we wouldn't be going back to retry all 3 counts, and it's possible that the prosecution could have decided not to retry the case at all. So, but here we are. They are appealing to the Massachusetts Supreme Court. I don't think that gets anywhere in terms of nullifying the first 2 counts, or declaring her innocent on the first 2 counts. So we will see what happens when she goes to trial on the 1st of April. Between that now and the 1st of April, we're going to see a lot of hearings. We're going to see a lot of motions, and Judge Cannoni is going to be making decisions on a lot of pretrial motions. The one to exclude Dr. Russell, and the one to exclude the FBI experts is just the tip of the iceberg. So I wanted to give you a quick update on the Vallow case. There's not a whole lot going on right now. Her request to represent herself was approved by the judge and was allowed by the judge. And she promptly then started filing motions. And the first motion was to order that Maricopa County Sheriff's Office release all of their records having to do with Lori Vallow. And it appears that what she was trying to do was to prove that the sheriff's office had disclosed confidential information having to do with information or communication that with her defense team that should have been confidential. So she was trying to prove that they had somehow disseminated that information that was communication between she and her lawyer and should not have been recorded or disseminated. But the judge said that because she was asking for all the records from all the time she's been in the Maricopa jail, that the request was overly broad, and would put a hardship on the sheriff's office to be have to create all those records, and probably 99% of them would be irrelevant to her case. And so the judge said he wasn't going to make the sheriff's office do that. Now, she has the opportunity to refile that motion and narrow what it is that she's asking for. So she may do that. She also asked for the disclosure of extradition records. So the record of her extradition from Idaho to Arizona. I'm not really sure what she hopes to accomplish with that, but nonetheless, there was that motion, and the prosecution asked for extra time to answer that motion. So as of today, the court had not ruled on that. She had previously had filed a motion that the court denied to compel discovery of the prosecution's emails and notes. Prosecution rightly claimed that that was work product and that they were not under any obligation to turn it over, and the judge agreed. The judge did say that the bulk of the emails that Lori had asked for were simply emails having to do with scheduling. And she was not entitled to their notes. So she is still on for trial in March. There was a little bit of confusion. There's a pretrial conference on the 18th, and then her trial starts on the 31st, and they will be trying the charges having to do with Brandon Boudreaux first. If you recall, there are two separate indictments, one for conspiracy to commit murder on Brandon Boudreaux for the attempt on his life, and then one for the death of Charles Vallow. So they're going to try the oldest case first, which was the Brandon Boudreaux case. Now, the way it worked out was Lori was already in jail in Idaho and facing murder charges there. They filed the case having to do with Brandon Boudreaux, but they held off on the Vallow case. I don't know whether they were continuing investigation, whether they were waiting for discovery in Idaho. I don't really know, but there was a gap. They weren't filed together, so Charles's was filed later. So the judge said that the oldest case was going to be tried first, and that's Brandon Boudreaux's case. It will be fun to get a preview of how she is going to conduct herself at trial. She does have standby counsel who are there to advise her, but she doesn't necessarily have to take their advice. So her trial's coming up the end of March, the 31st. Another case that we have been keeping a close eye on is James Craig. He is the Colorado dentist who is accused of poisoning his wife. And he's quite a fascinating character because he was set for trial in December, and on the eve of trial, his attorneys came to the judge and said, we have a conflict and we need to withdraw, and it is not a waivable conflict and we need to get off the case. One of the reasons why attorneys would do that is if they know that their client is about to lie in a material way. He's either going to lie to law enforcement, or he's going to lie to the judge, or he's going to perjure himself, and they cannot be in a position where they know what the true facts are. They cannot be in a position where they have to allow their client to lie when they know that what he's saying isn't true. And the reason why this comes up is because he has done all sorts of things to try and get to try and get inmates in the jail to help him build an alibi or a defense. So it started out when he asked one of the inmates um, to murder one of the detectives on the case. Um, that was ferreted out. Then he also solicited another inmate to commit perjury. And the way he did that was he tried to get the inmate to find one or two attractive women to say that they knew the victim and that she was angry because her husband, Craig, had been, um, James Craig, had been having an affair. And she was angry about the affair and wanted to frame him for a crime. Now, it sounds a little Gone Girl. Sounds like he's been reading those kind of books. However, it doesn't necessarily make a lot of sense because she died. Um, and there wasn't, he wanted them to put together this, to concoct this story that she was suicidal, and he approached a different inmate and wanted him to place letters at their house that would appear to be written by the victim to show that she'd been suicidal. He's also and then to also say, to go out and find these women who were willing to say, I knew the victim and she talked to me about trying to set up James Craig um, in a crime, to implicate him in a crime. It all doesn't really make a lot of sense, but that was his plan. So he got caught, and his lawyers withdrew, and they were forced to reschedule his hearing. So he has a preliminary hearing on the 14th of February now, and hopefully he's got new lawyers on board who are going to be able to take care of that preliminary hearing. The other one that is somewhat similar is Larry Millett. That is, his wife was Maya Millett, and this is a case where Maya disappeared and she's never been found. Her body's never been found, but they believe that Larry Millett murdered her. And he had a problem with a lawyer who was misbehaving and was censured by the bar, was under investigation by the bar. So he had to get different counsel as well. So his case was moved out until July. It was supposed to start on the 6th, 2 days ago, on the 6th of January. But it has now been moved out to the 7th of July. That one I think is going to be a really interesting case to watch, and I think it will be televised. It will be live streamed. Another little interesting twist to that case, and we are going to go on, there are a couple of other cases we're going to talk about that have similar issues, at least one other. But yesterday was 4 years since she had disappeared, and Larry's parents, in August, Larry's parents had been caring for the couple's children because, of course, Maya is dead and Larry's in prison and or in jail. And Larry's parents had been caring for the children. However, Maya's sister filed a formal action in court, and the judge awarded her permanent custody of their children. So the children are now with their mother's sister. And we're going to talk more about those type of cases and what happens to children when both parents are unavailable when we talk about Shanna Gardner in a little while. But I have a couple of other cases I want to talk about first. So first, I want to talk about Crystal Rogers. So Crystal Rogers is another case where her body's never been found. Her boyfriend, Brooks Houck, is the primary suspect, and he elicited the assistance of Steve Larson and Steve Larson's son, Joseph Larson. These are people who possibly were employed by Houck. He has a farm or some kind of a large property, and I think they were involved and employed by him working on the property. It originally all three of them were set for trial together. Then the judge ordered that Steve Lawson's case be separated out because he believed that there was a conflict between Brooks Houck and Steve Larson that were directly implicating one another. And so he ordered that Steve Larson's case be scheduled for February. So that case is going to happen. I don't have I didn't write down a specific date, but then Brooks Houck and Steve Larson's son, Joseph Larson, will be tried together, and their trial starts on June 24th. In kind of a sad side note, Crystal Rogers' father, a year later, Crystal Rogers' father never gave up looking for her. And there were particular places where Brooks Houck liked to hunt and liked to go out in the woods. And so Crystal Rogers' father continued to search for her body. And a year after Crystal disappeared, her father was found murdered out in the woods, presumably on a search for her. And to my knowledge, no one has been charged in his murder. I think that it's reasonable to believe that that Brooks Houck was in some way involved in his death as well. So, sad case. About 3 weeks ago, we watched the Joseph Verlazzo case. This was the young couple who were celebrating their first anniversary. Well, he wasn't that young, but she was. He was in his 40s. She was in her early 20s. They were celebrating their first wedding anniversary, and they had built out a small bus that they were using as a camper and traveling around. He was a tattoo artist, and he was traveling around and doing freelance tattooing. And he murdered her in their bus. He took the stand. His testimony was chilling. His real lack of remorse was scary. And his excuse in the very end was that she pulled a gun on him first and it was self-defense. But that was the first, at his trial, was the first anyone had heard of that. His sentencing is coming up. The defense has until the 15th of January to file any of their post-trial motions, and the state's doing a pre-sentence investigation. So the judge said he expected the sentencing to be set in February, but there isn't a specific date set yet. Probably it will be set after that January 15th deadline date. And then, and it may be that with the holidays, the state may be behind on creating the pre-sentence investigation as well. So we'll keep an eye on that one because I would like to see the sentencing on that one. Before I dive into Shanna Gardner, I had a couple of other kind of brief things to bring to your attention. One is on the Richard Allen case. If you were following the Delphi Richard Allen case, Richard Allen was accused of the murder of Abby and Liberty, and they were young girls, 13 and 14. He was found guilty and he was sentenced to 130 years in prison. There are very many people who believe that this is really a miscarriage of justice, that there were other forces at work, that there was misconduct in law enforcement, potentially misconduct with the prosecutor, and his attorneys are very aggressively seeking to have the case overturned on appeal. If you are familiar with Bob and Ali Mata, their YouTube channel is called Defense Diaries. Bob lives in Illinois, practices in Illinois, and the Delphi case happened in neighboring Indiana. So Bob attended the trial and most of the hearings because nothing was live streamed. And he became familiar with not only Richard Allen's family, but also the defense lawyers that were on the case. And Bob had one of the defense attorneys on yesterday, and the other two are one today and one tomorrow. There are three. And also interviewed the one of the defense investigators. Her name is Erica Morse. And so if you are interested in sort of the aftermath of the Delphi verdict and sentencing, they're very interesting podcasts to listen to, YouTube shows to listen to. And that's at Defense Diaries. And I will add the links to our community page here so you have them. It really is the first time we've had much insight into the defense. I found a little nugget having to do with the Long Island serial killer with Rex Heuermann, and I thought it was worth mentioning. The attorneys are wrangling over the DNA, same as in Kohberger. They're challenging the DNA at every turn, at every opportunity, and so they're wrangling. There's dueling motions happening over the DNA evidence. And if you all want a deep dive on that, I can do that. Just let me know, and we can kind of really get into what the issues are in both Kohberger and now in Lisk. But what I thought was interesting was the comment that the prosecution has. Get this. This is an unbelievable amount of data. 120 terabytes of data from 400 electronic devices that they seized. We knew that Heuermann had a lot of electronic devices. He had a lot of hard drives that had storage. A lot of things saved in storage on a lot of hard drives, a lot of other. We knew he had a lot of phones, but the very idea that they're having to grapple with that much data, I mean, that is, I'd have to sit down and figure it out. But we're talking about a building full of paper, and sometimes there's so much data you can't find anything, and a lot of it sometimes there's a lot of duplication, and you're like, oh, I've seen this page before, and you're trying to sort what you have, and it is a monstrous undertaking. I can't imagine what it's going to take to organize all of that data. This was one of the biggest problems in the Lori Vallow case. And in that case, they were only talking about 5 terabytes of data. And it was a huge problem. It wound up having the judge dismiss the death penalty as to her because of the prosecutors not turning over some of the things that they were required to turn over. And so it's a big deal. And I think it was a little interesting. I heard on the interview, Richard Allen's interview with one of the investigators, and she was saying that the volume of discovery, they were not sure that they had actually turned over, that they had actually seen and reviewed every piece of paper in that case. And they had multiple investigators working on all that information. And one of the downfalls in the Vallow case was, I think, the prosecution didn't hire a discovery clerk, that their only responsibility was to organize and categorize and account for every piece of discovery. Because had they done that, my opinion is that Lori Vallow would be facing the death penalty right now. So discovery is a really big deal. And the idea that they have 120 terabytes of information is enormous. Maybe somebody out there can Google it and get AI to tell them how many documents that really is. Lastly, I want to talk a little bit about Shanna Gardner. So Shanna Gardner is in a case out of Florida. She is the daughter of the family that created Stampin' Up, I think it's called. It's Jen's nodding at me. I can see Jen. You guys can't. The company was called Stampin' Up, and it was rubber stamps were all the craze. I mean, I think they still are. To make, to use in scrapbooking and to use in card making and those sort of things. Lots of rubber stamps and wax seals and that sort of stuff. Well, that was their business, and they became very wealthy thanks to that business. So Shanna Gardner, she's from a wealthy family. Jared Bridegan is a Microsoft executive. They get married, have kids, they have twins, and they get divorced. Bridegan then moves on, remarries. His second wife's name is Kristen. They have 2 children together. So now he has 4 children altogether. And he is driving home after having taken his twins home. And he has his toddler in her car seat in the back seat. When he comes around a corner and there's a tire in the middle of the road, and he stops his car and gets out to move the tire, and it was a trap, and a person jumped out and shot him. That person then confessed and told police that he had been paid to do the murder by Shanna Gardner, Jared Bridegan's ex, and her then husband. And so a couple of interesting things have been going on. Now, Shanna Gardner was found living with her parents in Washington when all of this came out and they um, indicted Shanna Gardner. She was living in Washington with her parents and the twin children. So the police arrested her in Washington. The children stayed with her parents and they extradited her back to Florida, where she is awaiting trial. Now, I'm pretty sure I wrote down the date here. So let me just, yeah, so she was arrested in August of 2023. And since then, the twins, who are now 12, have been living with her parents, their grandparents. So back in Florida, the prosecution is seeking the death penalty. So it's interesting that, of course, her family has had the wherewithal to hire very high-powered lawyers like Jose Baez, and her husband is indigent and Hispanic and has court-appointed lawyers. And her attorneys have filed 6 different motions trying to block the death penalty for her. But her husband's attorneys have not filed similar motions. The defense also wants the defense also has filed a motion, and this is somewhat interesting, that the murder happened in 2022. That was before the Florida legislature changed their jury law. And Florida recently changed their jury law, which I hate. As a defense attorney, I think it's just horrible. But they changed their law so that they no longer require a unanimous decision, that they can convict on an 8-4 split, or a 9-3, or a 10-2, or and so that has not been, the court has not decided that yet, but it seems to me that if the case started before the law changed, then she should be under the old law. It's similar to Chad Daybell's case, and whether or not he would be subject to Idaho changing the law to allow executions by firing squad. So the question was, would he be eligible for that? And I think the answer is no, because they changed the law while his trial was pending. He already was in the pipeline at the time that they changed the law. So similarly, I think here they're going to be able to say we need a unanimous jury, and the defense is really pushing for that. So here's some interesting, and there are times in our world where family law and criminal law come together. And I did both family and criminal law. And there are times that I think, okay, well, I probably understand this because I did criminal law, I did family law, I also did juvenile law, child protective services, foster care work. So I kind of understand how all those systems move together. Because recently there was a dispute between Shanna Gardner's parents, who live in Washington, and Jared Bridegan's parents over custody of the twin 12-year-old twins. Now, these were the children that Jared Bridegan had with Shanna Gardner. Now, he has 2 other children with his second wife, whose name is Kristen. So the grandparents were arguing over who should have custody of those children. Now, there's some really very interesting case law, and I'm about to mess around here and change my lighting when I pull up my um, screen here. Come on. There we go. Because I want to share my screen with you to talk a little bit about a, a Supreme Court case that came out in 2000. So bear with me. I'm going to share my screen. No, I don't want that. I want share screen. Here we go. See what happens. I'm off for a couple weeks and I forget myself. So this is a case that came before the U.S. Supreme Court in 2000 and has been sort of a factor in my practice for quite a long time. So this case, it came out of the state of Washington, which is a little bit interesting. And there were several cases at the time that went all the way to the U.S. Supreme Court. And then the U.S. Supreme Court issued this decision sort of as an umbrella that really impacted all of those cases that had gone up to the U.S. Supreme Court. So the issue was in the state of Washington. The state of Washington had passed a law that said any person could petition for visitation rights at any time. And then the court had the right to decide whether visitation would serve the children's best interest. They also ruled that any person could petition for custody of a child. And the reason they did this was to give step parents the possibility of having some rights in the case where you have a person who's been a long time step parent to a child, and now that marriage dissolves, and the step parent no longer has any rights to have a relationship with a child that they've probably partially raised. And so the U.S. Supreme Court in 2000 came back and said that the 14th Amendment's Due Process Clause has a substantive component that provides heightened protection against government interference with certain fundamental rights and liberty interests. So in the law, we're always talking about whether the Constitution protects a fundamental right or liberty. And so the court said that, in effect, that the right to raise your children, what they said was, it was the fundamental right of a parent to oversee care, custody, and control of a child, unless the parent was either unavailable or unfit. So a lot of states then filed some their own laws in line with Troxel versus Granville. And what it meant was that it limited third party, non-parent parties in their way that their rights to petition the court for custody or visitation. So, and that included grandparents. So there were two different, in Oregon and in most states, what they did was they sort of broke it down into two different tests. One if you were asking for custody, and one if you were only asking for visitation. So in the case where a third party was going to ask for custody, they had to prove, first of all, the threshold question was, is the parent unfit or unavailable? Now, I argued a couple of these cases. I had a couple of these cases and won both of them on behalf of grandparents. because we were able to show that the parents were either unavailable or unfit. In one case, dad was in prison, mom was a very, very serious drug addict, and therefore unavailable. But the judge, after the judge gets over that question, are the parents unfit or unavailable? Then the judge has to ask these questions. So think about this in terms of Shanna Gardner. Jared Bridegan, the father, is deceased, and Shanna Gardner, the mother, is being held in jail pre-trial on charges of murdering Jared Bridegan. So clearly neither one of them are available, and there has to be some other resource for the children. So then the judge has to look at a whole long list of other factors. And the very first paramount factor is what is in the best interest of these children. And to figure that out, the judge has to then has to look at the bond that the children have with both sets of grandparents and the history of the child, including any abuse or neglect or trauma having happened because of the murder of their father. And the judge has to sort of, as part of the best interest test, has to really look at the impact on the child of restricting grandparents from having custody or restricting their visitation. So after considering all of those factors, and probably the most important factor is that the children have been with Shanna Gardner's parents for over a year now, and have settled in there, the judge denied the Bridegan's motion for custody. He did, however, find that they had a visitation right and that they had an ongoing close relationship with these children. Now, do I think that the Shanna Gardner's parents are going to facilitate visitation with those children? No. The Bridigans are going to fight every way from Sunday to see those children. And I don't believe the Gardners are going to be that helpful when it comes to seeing the children. Now, we saw this in the Markell case as well. We saw grandparents, Ruth Markell, and this is Dan Markell. This is the Adelson case out of Florida. So Wendy Adelson is still out in the world and has legal right and custody over her children, who were her children with Danny Markell. The Markell grandparents have had a very difficult time and have gone back and forth in court to try and get any sort of visitation and have a relationship with their grandchildren. And that case is over 10 years old. So Donna Adelson is in jail awaiting trial. I don't think a new trial date has been set for her yet because she had to get all new lawyers. And that sort of brings to a close. They started out with the hired gunman. They convicted them. Then Katie Magbanoa, who was the middleman, and then Charlie Adelson, the brother, and now Donna Adelson. Your guess is as good as mine whether or not the prosecutor has enough information to indict Wendy. I kind of think not, but maybe. And in the meantime, the Markells have been trying very hard to see their grandchildren, and Wendy Adelson has made it very difficult at every turn. She has not been supportive of them having contact with the kids, and they have had very little communication with those boys at all, who are now young teenagers. So they were 2 and 3 when Danny Markell was murdered, and that was at least 10 years ago. So they're young teenagers at this point. So it's always a difficult it's a difficult question. Um, like in the Gardner case, the Gardners didn't have the Gardner grandparents didn't have anything to do with Shanna Gardner having Jared Bridegan killed. But you can see where the two families are going to be blaming each other, and there's hard feelings, and that is going to trickle down to the children. I know that Jerry Bridegan's family and Kristen Bridegan, who was um, his second wife and so stepmother to the twins, has very much wanted her children, her two, to have a relationship with their older siblings. Um, and that was part of the reason why the Bridigans wanted custody, but the judge wasn't having it. So, and we don't know all the details, but I will say that judges usually one of the things they don't like to do is to disturb a placement that's working. If the children are with the Gardners and they're doing well and they seem to be sort of recovering from this trauma and the Gardners have been able to help them do that, then the judge is going to be really hesitant to change something that's working. And the Bridigans, I think, just couldn't prove that the placement with the Gardners was in any way detrimental to the children. So interesting things to talk about. It's now time for questions. So as we are doing that, as Jen is queuing up questions, I do want to ask, for those of you who are prayerful types, for some prayer tonight. First of all, I want to say that we had the best holiday. My daughter moved back to Central Oregon. My husband and I moved back to Central Oregon. This is the first year in about 3 years that we really had a place where we could host the holidays. Our house in Idaho was very small and temporary, and so we invited the whole family here to Redmond for Christmas. So we're very blessed with the fact that we are very close to my son-in-law's parents. So they came. We had the whole family here at Christmas, except his twin brother. We missed him. And it was absolutely wonderful. It was magical to have them all here. We all like to cook. My son-in-law's dad is a wine aficionado, so we had what my mother-in-law calls the days of gluttony and celebration, and so it was fabulous. We really had a wonderful time. So they went home. They live in La Cañada, California, which is right on the edge of Pasadena. And we got word this morning that at 4 a.m. they got the evacuation notice, and all of La Cañada, much of Pasadena, has been evacuated because of wildfires. Santa Ana winds are whipping up down there. They've had wind gusts as high as 100 miles an hour, and right now they are saying that the next peak wind time is going to be from 10 p.m. Pacific tonight until 5 a.m. The firefighters are absolutely working. Oregon just sent 21 teams down there. I know other states are sending teams right and left. And one of the problems is that the tanker aircraft can't fly because of the high winds. So they're literally doing this with fire trucks and sort of hand to hand. Huge swaths of Altadena, which is a neighboring community, have already been destroyed, thousands of houses. One of my son-in-law's very good friends, their family lost their house yesterday. So For those of you who are prayerful, please say an extra prayer for my La Cañada family, Tony and Roger. And please say an extra prayer for all of the people who are facing such tremendous loss. As I was thinking about this, um, my son in law's parents have lived in this house since for at least 20 years, since he was very young. And it's their home that houses all their memories and all of the good things about their family. That it's the locus of all that life and memory. And to they were able to evacuate. They went to their son's house first, my son-in-law's twin brother, and then on to some friends who offered them a place to stay out of the risk area. Um, so they're okay, but to have to sit there and be so helpless, just helplessly watching and waiting and hoping that your house is going to be standing when you go back. So, not just for them, but for everybody who's in that waiting place. Yes, prayers for people who have animals. In Central Oregon, we are very acutely aware of wildfires. We deal with the threat of wildfires every year, and we generally have within the sheriff's department, within the fire department, within the sheriff's posse, we have teams that have been set up to help people get their animals out, particularly horses and livestock. And so those teams get set up. I know they have similar things because a lot of those areas up in the LA Hills, although LA is really populated, there are a lot of places up in the LA Hills that are more rural where they do have horses and livestock. So, but yes, I saw a quick clip of the actor Steve Guttenberg down there helping people, helping move cars out of the way so that they could get fire rigs into Pacific Palisades. They were telling people, if you park your car on the street, leave the keys in it because we have to be able to move it because of the fire danger. My son-in-law's mom went to high school in Pacific Palisades. A lot of her friends and her old high school are already gone. A lot of their houses are already gone. So please, prayers for all of LA, and prayers for my family in particular. And thank you. I also want to say, for those of you who are in the Tucson area, I'm going to be, or want a little sun vacation, I'm going to be on 2 panels at the Tucson Festival of Books. Both of them are true crime panels having to do with, one of them has to do with cases in the headlines. The other one has to do with cases that involve families. So those are going to be really interesting. I'm on with, and both panels with 2 other authors. So I'll get more information out as time goes on, but that is the 15th and 16th of March at the University of Arizona in Tucson, U of A. Tucson Festival of Books. You can Google that and get to their website and get all the information. And so I hope that we'll have people that are in the area or who would like a little bit of a sunny getaway, come on down and join us. So other than that, I don't have any book appearances scheduled right now, but thank you, Jen. But definitely, if you are at all interested and it's travelable, let me know. And book sales are going well as far as I can tell. So, and I want to say thank you to all of you who pre-ordered books, who got the early copies and posted reviews. I must admit that I follow the advice of a lot of other authors, and I don't read reviews. But I over the Christmas holiday, one of my friends said I read all the reviews and they're good. So thank you for that. I appreciate it. Well, let's move on to some questions now that I've babbled along and given Jen a little time. Interesting. Hi, Jane. Jane, you always come up with really good questions, and I like this question. What did I think of Jake Wagner's sentence and his allocution? I thought his allocution was incredibly predictable. And it was exactly what every judge has heard a gazillion and two times. So I did not think that Jake's allocution in any way really impacted um, the judge's decision. I think the judge sort of said, okay, you can come and say your piece, and I can hear that you're a new man, and that that you regret what you did, and okay, all is good. I mean, I think there's always a question when somebody makes that sort of an allocution. Is it real, or are they just saying it because they're sad that they're going to prison? And I don't know that at this point anybody can really assess that when it comes to Jake Wagner. But I had to agree with the judge's sentence, and here's why. The only person that went to trial um, got life in prison. That is Brother George. But Mother Angela only got 30 years. And she made a deal. Now, I guess you could say Mother Angela, her argument was, I was less culpable because I didn't pull any triggers. The judge didn't really buy that. He said, you could have stopped this with a phone call, and you didn't. And, it was very clear that she was sort of the moving force in all of that. So I really thought that the judge was very thoughtful about this in saying, the prosecution came to you and said, if you come and testify against George and against your dad, and you testify truthfully, we will recommend a more lenient sentence. The prosecution kind of waffled on that, and the judge just said, no, this is a fair sentence. He did everything he was supposed to do. He held up his end of the deal, and I'm going to give him the same sentence that his mom got. So I thought what the judge did was very even-handed, very fair, and I thought it was the right thing. I knew that, yes, he pulled the trigger, but if you know enough about that case, I'm not convinced that Angela was any less culpable. And I think the judge was not convinced of that either. I was happy to see that the grandmother basically was released, and went home that day. I think that it was very clear from her um, presentation allocution that she's pretty confused. Um, at the end of it, she had to look at the judge and say, so I can go home. So I think she's suffered enough in all of this. So I was happy to hear that she went home. And I think that the sentences for Jake and Angela were reasonable, considering the deal they made to testify against the dad and the other brother. Good question, though. Hi, Debbie. Thoughts on Lori representing herself? Well, I think it's going to be worth the price of admission. So here's what I think. I think Lori very much wants to get into things that are not relevant. And I really think that Lori she wants to get in somehow her her for those of you who may drop back. At her allocution, she said there were no one was murdered. Suicide happened, drug reaction happened, accidental death happened, but no one was murdered. So she expanded on that in a conversation she had with her son Colby that he recorded and put out on his YouTube channel. Now, I think there's has to be some question about whether he helped Lori, maybe inadvertently, get that information out, or whether he felt the need to go on record saying that's absurd. Because Lori went on his, she had a phone conversation with him that she knew was going to be recorded and replayed. And in that conversation with him, which was the first conversation they had had since the recorded conversation that was played in court like 3 years ago. And in that conversation, Lori told him that Tammy Daybell died from some reaction to medication, that she was not murdered, and that Tylee accidentally killed JJ and then took her own life. We all, to a person, agreed that that was absolutely horrendous of her to try and throw her dead daughter under the bus. But she's done that with almost everybody else except Chad. And so maybe not a huge surprise, but really disgusting and heinous of her. I think that one of the reasons why she wants to represent herself is that she thinks she is going to be able to get that information in front of the jury in Arizona. I don't think she's going to be able to do that. And I think that she had a basic disagreement with her lawyers about going into that. I think her lawyers told her those deaths happened after Brandon Boudreaux was shot at, after Charles Vallow was killed, and they have nothing to do with this case. But I think Lori is going to try everything she can to get that information in front of the jury because I think she believes it helps her. It doesn't. It doesn't help her because though what happened in Idaho after these events has absolutely nothing to do, it's not relevant to the case in Arizona. I think her lawyers tried to tell her that. I think she argued with them. And I think that she fired them because she is so intent on getting that information out and getting it in front of the jury. I don't believe the judge is going to let it in. I think that it is inadmissible. It's not even prior acts. It's anti-acts. It's post-acts. It's not even prior bad acts. So I don't think a judge is going to let it in. I don't think it comes in under the rules of evidence. But I think that is one of the reasons why she decided that she had to represent herself because no lawyer was going to put that evidence before a jury. And for one reason or another, she thinks somehow that that will impact the outcome. So the first case is going to be tried as Brandon Boudreaux's, which is the case where Alex Cox took a shot at him and attempted to kill him. So that one is going to go first. I think it's going to be a circus. It's going to be worth the price of admission. It's going to be live streamed, and everybody is going to get your popcorn ready because it's going to be worth watching. I do think that it will raise a lot of your questions for you, legal questions, because when you watch a live stream trial, a, a lot of the legal sort of wrangling that goes on sort of goes on in a sidebar or it goes on in preliminary hearings, and the public doesn't see as much of it. But because she's representing herself, the judge is going to be very careful about making a record of every ruling. So we are probably going to have a lot to talk about because a lot of it is going to happen right out in the open. And that at least that's the way the typical pro se case goes. So it's going to be fun. And I don't know whether we'll cover it live or not. We might. So, other questions? Oh, what motions has Bad Lori filed? So, she initially filed a motion to compel discovery because she wanted prosecutors' emails and notes. So, the judge denied that, saying that it was attorney work product, that the emails that she wanted mostly had to do with scheduling, and that she was not entitled to the prosecution's notes, which she's not. That's work product. The prosecution's notes, their opinions, their their snarky remarks in the margins, all of that is she's not entitled to. So, so the next motion she filed a motion to get all of the records having to do with her time in the Maricopa jail. What she was specifically was looking for, what the judge said he believed she was looking for, was evidence that the jail had violated her confidentiality rights with her lawyers, that they had somehow recorded and disseminated conversations that she had with her lawyers. If so, that's certainly improper. But the judge said that the motion was so broad that it would be a lot of information that wouldn't be anywhere near relevant to Lori's case. I mean, administrative documents and just sort of basic, she moved here, she moved there documents that were not going to have anything to do with the communication she had with her lawyer. So the judge denied the motion, but Lori can refile that and be more specific about the records that she's looking for. The next thing she asked for was also records having to do with her extradition. I think what she's looking for is any statements that she might have made in the 2-day trip between Idaho and Arizona, because there was a 2-day road trip that she made accompanied by several officers, including a female officer that was with her the whole time. So I think that's maybe what she's looking for, but the judge hadn't ruled on that as of this morning. The prosecution had asked for more time and the judge hadn't ruled on it yet. So, but those were the motions she's filed so far. We'll see what else she comes up with. She does have standby counsel. The last attorneys, thank you, Jen. You can put that back up. The last attorney, thank you. The last attorneys that were appointed for her have stayed on as her standby counsel. So she does have lawyers advising her. She does have the ability to create motions and run them by her counsel. This is a good point here. We were talking about how in Rex Heuermann's case, there is 120 terabytes of information. Jen just put up that a terabyte could store the equivalent of 85 million sheets of paper. Now, we know a lot of that is not paper or reports or text, we know a lot of it is video. And video does take up more room than paper, than text, but still, 85 million sheets of paper in 1 terabyte, and we're talking about 120. Somebody said 120 terabytes could actually fill an urban library. That's the amount of text in books in a typical library. So it's a lot. And he has waived his right to a speedy trial, so they're in no hurry. And his defense team isn't in any hurry. They have a lot to paw through. If you were to print out 120 terabytes of data on standard paper, it would roughly equate to 9.9 billion with a B pages of printed text. Yeah. So we know that not all that data is text. We know that some of it is video, probably a lot of pictures, but nonetheless, it's a lot. There were reams and reams. Think about in the Vallow Daybell case, there were somewhere around 20,000 SMS text messages that went between all the players, between Chad and Lori and Alex and Zulema and there were 120,000 text messages alone. That didn't even begin to talk about photos that were in her iCloud, emails that were in their iCloud, police reports, photographs, all of that stuff. And in Rex Heuermann's case, he had 400 devices. Lord only knows what was on all those devices. He does appear to be a meticulous planner from the planning document we saw. So, and it is very possible that he also documented things on that electronically in those devices. We don't know what's in those devices. We know that the BTK killer kept a very graphic journal that included drawings, and he was a pretty fair artist, of his victims. And so we also know that that he wouldn't be the first one to have kept photographs. Several serial killers kept photographs. Jerome Brudos, who was from Oregon, comes to mind. And they found photographs of his victims. So I don't think it's, I think that it is a monumental task. I know that a lot of investigators and lawyers are now beginning to use AI, artificial intelligence, to be able to catalog and screen documents. You know, they can give the AI program parameters and say anything that says this goes in this file, anything that says this goes in this file, and they have at that point sort of done a basic sort. From there, they can then refine what it is they're looking at. They can teach AI to weed out duplicate pages so that they're not having to go through and say, okay, I've seen this already. This is the 4th time that they've produced in discovery this same police report. So sometimes what happens, especially with police reports, is you get a police report and it is report number 5. And then you get the officers continuing to do investigation, and you get a supplemental report. So that becomes 5.1. And then another officer finds something else and they file a supplemental report, and that becomes 5.2. So it's cumulative, but every time they add a supplemental report, they produce the entire report back to the the prosecutor and then back to the defense. So what happens is you might have the same police report that has been produced 15 times because there's 15 supplemental reports. You really only want 5.15, the last one, because it has everything. But you're going to have to realize, oh, you're going to have to go through it and then realize, oh, I've seen that report before. Oh, yeah, and AI may be very well, maybe very well able to weed that out, and so that you only get 15 point or 5.15 with all the supplemental reports. So there are some great places where defense attorneys are able to use AI. On the other hand, there are some dangerous ways that it was being used initially, and that was the idea that you could have Chat GPT craft you a motion to suppress on a case and these facts. But there were lawyers who discovered that Chat GPT, that they didn't check their work, and that Chat GPT was just throwing in case citations as placeholders. And the case citations weren't real. And a couple of attorneys got in some pretty deep water for filing what amounts to fraudulent documents because they were citing cases that didn't exist. So lawyers have learned to be way more careful about how they ask AI to assist them. But I think one of the ways that AI can be really valuable is in sorting through discovery materials. There's no question that that humans need to check AI work. We should not be relying on AI to do our work. We should be going behind and checking. But some of the more menial tasks, like just going through page after page of discovery and pulling out duplicates and making sure that you have every date stamp page and all of that, can be done by AI, because that isn't rocket science and doesn't take a human brain to evaluate and make a judgment call. AI works when the computer can say yes, no, 1, 2. It isn't so good at decisions that require some kind of subjective judgment. So, good questions. Any thought on money influence in trials? Shanna Gardner and Anderson Brothers in Florida. Oh, I have many thoughts. Girl, I have thoughts. Thanks, Debbie. I have thoughts. We know that when a defendant has a lawyer who is being paid, first of all, we know that they have enough money to go out and get the lawyer who has the experience, the intellectual ability, and the time to try the case. And that means that you have a lawyer who is smart, gifted, and you can pay that lawyer to exclusively focus on your case. Or maybe that lawyer has 2 or 3 very high profile, expensive cases. And that lawyer can devote their time and their intellectual energy and their thought and their applying their experience to that case alone. Then you compare that, contrast that with an indigent client who can't afford a lawyer and who is appointed a lawyer. Now, I will tell you that the public defenders that I've worked with are some of the smartest, most honorable people I know. But they're forced to triage cases because they only have a finite amount of time, and their state contract has expectations about the number of cases that they are going to move through the system. So they triage cases. They look at the cases. First of all, they look at the cases where the facts really don't lend themselves to a trial. And what I mean is, many cases, um, in many cases, it's pretty cut and dried. Um, they got the guy on surveillance video committing the robbery. You're going to go and you're going to argue with the prosecutor for the best deal possible, but you're probably not going to take that case to trial because it's a pretty slam dunk case. On the other hand, if the guy is a guy who's can afford to go out and hire an expensive lawyer who's going to come in and say, okay, well, I need to get an expert to come in and really review that surveillance video and find out whether or not there are any deficits in the timestamps, so there's anything weird about the way that footage is stored. I'm going to bring in I'm going to bring in somebody who's going to challenge the eyewitnesses who said that the client was there. I'm going to bring in, and every one of those stages, the attorney who has more resources is going to be able to bring that to bear. Now, possibly what that means is he's going to raise enough doubt that the prosecutor is going to make him a sweet deal. Or he's going to say, we're just going to take it to trial and the chips are going to fall where they may. And that lawyer may be able to poke enough holes to create reasonable doubt about whether or not the video is real, whether or not it's been tampered with, whether or not it really shows what it shows at the time that it shows. All of those things, those are resources that really aren't available to the average public defender who's triaging cases. So that public defender looks at that case and says, man, the prosecutors have got you cold. They've got you on video. So let's try and cut the best deal we can. And that's the way that the public defender is going to have to approach it. Because the public defender does have cases where they feel that there's a better chance that a trial could lead to a not guilty verdict. So they're going to start, first of all, by triaging out the cases where they feel like the prosecution's got a slam dunk, particularly if they've got a client who already has a criminal history and has already been down that road. And I mean, there's a lot of factors that go into that. But the public defender who's got 100 open cases is triaging cases and is trying to figure out, this one's going to settle. I can settle that one. I can settle this one. Ooh, the facts on this one, this could be a decent trial. I could make a decent argument that this person's not guilty. I could bring in an expert or an investigator, and I could figure out, I could present a case where a jury could find this person not guilty. So the DA or the public defender is having to make tactical choices about what case they can win and what case they can't, and focusing their attention on the cases they think they can win. That's different from a retained attorney who's only got a handful of cases and there's plenty of money. That attorney can take their time. They can sit at their desk for 3 or 4 hours and stare into space and think about the case. Public defenders don't have that luxury because there's another case coming through the door. There's one going out that got settled and the next one's coming through the door. And that's the way it works. It really is assembly line, pipeline justice. It's not right. There is no universal way within our country that public defense is provided. It's provided state by state and sometimes county by county. So in some states, the county is responsible for providing court-appointed attorneys, which means that every county does it a little bit different within the state, and every county decides how much money they're going to devote to public defense. And so you get really uneven results. We are facing a national crisis within public defense right now. And that is because public defenders have been chronically underpaid. Within the state of Oregon, when I got ready to retire, public defenders were making the same. So in 1999, when I retired, public defenders were making the same amount of money per case that they were being paid in 1980, in 1982, and 1988, and every 2 years when the biennial budget was decided. And every time public defenders would renegotiate for a new contract, they would say, well, we'll give you a little bump up in rate, but you got to take more cases. They paid on a per case basis, which is unconstitutional. So the state of Oregon has been trying to overhaul their public defense system since 1998, when the Sixth Amendment Committee, which is a national nonprofit organization, when the Sixth Amendment Commission reported, did an analysis of Oregon's system and reported that they were operating in an unconstitutional way. The state has been trying for the last 5+ years to rectify that, and it still hasn't happened. The current governor has now allotted about $10 million to try and rectify the system. But when you have public defenders who are making 1/3 of what prosecutors make, and they're contract employees, so they don't get retirement, they don't get vacation, they don't get health insurance, they don't get pensions, they don't get any of that. That's all has to be done on their own. And they're making 1/3 of what the prosecutors are making, and prosecutors are state employees. In my home state, the only person who is a county employee is the elected district attorney. All of the other assistant DAs are paid by the state of Oregon, and they get generous paid vacation, sick leave, health and gold Cadillac health insurance, state pensions, and the option to opt into 403Bs, which are like a 401k, where the employer matches your contributions. So they've got Cadillac plans, they're state employees. And public defenders are private contractors who contract with the state to provide a service. So they're paid on 1099s and they're contracted through the state. The state of Oregon, now there are some states who have a state public defender office, but for every one of the state public defenders, they have contract attorneys as well to deal with conflicts. And none of the states are doing a good job. And all of those contract attorneys at this point are way overworked and way underpaid. Well, what that results in is we can't get young people coming out of law school to go into public defense. They take one look at it and say, that's crazy. I can go into private practice doing criminal defense and get paid Jose Baez wages. I can go into to criminal defense as a state attorney general or as a deputy DA, and I can get on the state payroll and I can get all the state benefits. Why in the world would I do the same job for 1/3 of the pay? So we're unable at this point to get new public defenders, which means that the guys like us that are retiring, the people like me, and I just had lunch with one of my colleagues last week. He's working on retirement and heading toward retirement, and he's one of my contemporaries. And he says, one of my biggest fears is they won't be able to find somebody to replace me. One of the reasons why I was really intent on wanting to move out of Central Oregon when I retired was I love my colleagues. They're dear people who are really dear to my heart. And I knew that if I stayed, they would suck me back into helping because I hated to see them become so overloaded. And I think that's true for all of us. We get into public defense because we have a heart for it, because we care, and because it's righteous work. And we are fond of our coworkers and our colleagues. And it's hard to see them so inundated and overloaded with work. So there is a huge money divide. People like Shanna Gardner and Mangione and the brothers in New York who can afford these teams of lawyers. And as an example, Karen Reed has sold everything she owned, spent everything she owned. Her parents have gone into debt, and she is still with this private team that she's had. She is still $5 million in debt to her lawyers and the expenses associated with her trials. That's horrendous. It's horrendous that she has to do that, but it's also horrendous that money buys a different kind of due process. Now, I'm not going to say that money buys a different kind of justice because I'm not going to go there. I'm not going to go that far. But I am going to say that money buys a different kind of due process. It buys more investigators. It buys people who can go out and really dig. It buys more experts who really understand cell phones and can figure out when Jen McCabe Googled how long to die in the snow. It buys more of those people. And those are the resources that the average public defender and the average indigent defendant don't have. And it really is not until you get to capital cases that you find lawyers doing the kind of deep, intensive investigation that every defendant deserves because they simply don't have the resources and the time. I will give you an example. The last 5 years of my practice, I did primarily work with foster cases with children who had been removed from their homes. And I represented children. I sometimes represented parents, but primarily I represented children that were in foster care as they were going through the system of whether or not they could be returned to their parents. At one point, I had 118, I think, children on my caseload. Now, some of them were family groups, some of them weren't. And even with family groups, sometimes the children were split up into multiple placements. And there was an expectation from the state of Oregon, who was paying me as a public defender, that I would see every one of those children once a month. You do the math. I had to be in court at least 3 full days a week. Not all of these children were placed within a 50-mile radius of me. Many of these children were placed in other parts of the state because they needed treatment that couldn't be provided within our geographic area. So out of 118 children that I was responsible to see once a month, many of them were all over the state of Oregon. Now, the state of Oregon is a good sized state. It's 300 miles border to border. from Central Oregon everywhere is about 150 miles or more. So once every 3 or 4 months, I would make a 3-day circuit all the way around the state, and I would visit as many of my remote kids as I possibly could. But that was the best I could do. And the state's expectation was that I would see every one of them once a month. The math just doesn't work. So that and that problem is translates into adult work as well. You have 100 open cases. You've got people who might be in jail in the local area, or they might be out on release. And if they're released, they might be all over the state. They might. There are a number of reasons why you're trying to see all your clients, and it's just not physically possible. So yeah, money makes a big difference. I know we're 10 minutes over our 2-hour time frame, and I'm on my soapbox. Money makes a huge difference. And people like Shanna Gardner and Luigi Mangione and the brothers from New York that have all the money, they get better due process. They just do. And it's wrong. And it is something that I'm really thinking about a lot when it comes to my next project. I'm thinking very deeply about how our the political climate in the last 10 years has impacted criminal justice in general, and the ability of public defense to really do their jobs. It's hard because we have what appears to be sort of a shift to an attitude of overreaching power by the government. And at the same time, we have a weakened public defense system that is the bulwark against government overstep. And that is a problem. And I think that it is going to lead to more of these unjust outcomes. And I might want to write about that. So thank you for asking those questions. You guys always ask the best questions. You know, I started this channel as a way to connect to the community, and really as a vehicle for the book. And I am incredibly appreciative at the amount of support that this community has had for me and for the book. I never intended for it to be my job, or to be a cash cow, or to be I don't even care if YouTube demonetizes me because they say murder and suicide and they don't like those words. I never really intended, but I love the fact that I've been able to connect with this community. And I love the fact that the folks who come every day and sit with me on Wednesdays are loyal folks, people who come because we make something together. It's wonderful. So thank you for all of you who are here in the chat, and thank you for all of you who are in the replay crew. I saw earlier a post saying hello from Finland. So hello, Finland. And to the folks who get up in the middle of the night to watch, thank you. I appreciate you. And I love what we do here. And I love that we conquer kind of hard questions like we just did. And I give you my thoughts, but I also love that you feel free to give me your thoughts in the chat. If you are not comfortable giving me your thoughts in the chat, by all means, drop them in the comments or email me, because I love hearing from all of you. Please, I am back to working on quilting projects. So we are still collecting crane squares for the woodcocks, and I'm going to get to work on that quilt. That's my number one priority. And but please, if you want to contribute a paper pieced quilt square, the link is in the description below to my Google Drive, where you can find the pattern and the instructions. So thanks so much tonight for joining us. Thank you as always, Jen, the beautiful Jen, for keeping us on track and keeping track of the chat for me, because I can't walk and chew gum and I can't keep track of the chat at the same time. Those of you who've been around a while and have seen the times that I've attempted it, it's not pretty. So thank you, Jen. With that, I'm going to say good night. I hope that all of you had amazing holidays and that 2025 is going to be incredibly good to you. And thanks for always being here. Good night.